Welcome back to One Stop Law. Now, in this video, we will look into another very famous legal maxim, that is caveat emptor. Now, what is caveat emptor? Caveat emptor is a very fundamental principle of the law of sale of goods. As you can see, the maxim constitute of two words, caveat and emptor. So basically, caveat means beware and emptor means buyer. So together the maxim means buyers beware or let the buyers beware. So basically this is a maxim which talks about the responsibility of the buyers before they buy certain products. See, it is after all the money of the buyers. So buyers have to be extra cautious before spending their hard-earned money. So that is the bottom line motive of the maxim, to make buyers make responsible choice. They should first inspect the goods properly and find out whether it suits their purpose or whether they have any defect. And the maxim is very just in considering that it is not always the duty of the sellers to point out the defects of his goods to his buyers. Buyers should also exercise their due diligence and make a proper responsible choice. They should inspect the defects before buying, before spending their money. They should exercise their due diligence and be, if they buy certain thing without inspecting, they should be made responsible for their choice. In India, the Sale of Goods Act 1930 contains the doctrine of caveat emptor under its section 16, which states that there is no implied warranty or condition as to the quality or fitness of any particular purpose of goods supplied under such a contract of sale. So basically it tries to say that when a seller makes his goods available in the open market, then the buyer previews all his options before making the final sale, before buying it, and then accordingly he makes his choice. So now say, let's assume that the product, after the buyer buys it, turns out to be defective or of inferior quality. Then as per this doctrine of caveat emptor, it is not the seller who will be responsible for it, because the buyer himself is responsible for the choice he made. So the doctrine attempts to make buyer more conscious of his choice. It is the duty of the buyer to check the quality and usefulness of the product he is purchasing. If the product later on turns to be defective or does not live up to his potential, then the seller cannot be made responsible for it. You can see there is a case law given of Ward versus Hobbs. In this case, pigs were sold to all faults, and the seller knew that the pigs were suffering from sore fever, but he did not inform the buyer about this defect because the buyer never asked of it before buying. He just came and bought the pigs. So the seller was not liable for damages because there was no implied warranty as per section 16 of the Sale of Goods Act, as per this doctrine. Now, before I take you through the exception of to this doctrine of caveat emptor, let me give you another example. In a certain case, A bought a horse from B. Now, A wanted this horse to enter into a race, but later on, when he took the horse home, he found that the horse was not capable of running a race because it was lame. Now, in this case, A never informed B of his intention that he wants a horse which can run a race. So, in this case, B, as per the doctrine of caveat emptor, will not be responsible for the defect of the horse because B was never told by A that he wants the horse to run a race. Now comes this exception. Now, what would have happened if A would have actually told B that give me a horse which can run a race and win it for me? In this case, in spite of knowing that the horse is lame, if B would have sold that horse to A, in this case, A is not at fault as a buyer because he had made his intention very clear, the purpose of his buying the horse. In spite of that, if B would have sold him that horse which is lame, which cannot run a horse, in that case definitely it is the liability falling on the B, that is the seller, who is responsible, who is liable for fraud under this transaction, because A as a buyer had made his intention, his purpose very clear to the seller. Otherwise, until and unless the buyer makes his intention of buying a particular product very clear, his intention of buying this product or any product to the seller, till the time he makes his purpose clear to the seller cannot be held liable for any defect in the product under the doctrine of caveat emptor. That's all for this video. Till I see you in some other lecture. Thank you all.